Good morning, class. Today we'll start with the third revision class of Law of Persons. Now, in this class, we would primarily discuss the law relating to corporations. Corporation being one of the most important legal personality in jurisprudence. Now, here we would be discussing the main parts, which would be the kinds of corporation, that is the corporation aggregate, corporation souls. Then we would be discussing some case laws, and then we would be discussing the features of corporation. But then there are certain more topics which you would be reading afterwards in company law, for example, lifting of corporate veil, then civil and criminal liabilities of a corporation. Those topics are equally important, but insofar as our jurisprudence course is concerned, we are concerned with these three little things only. Now, insofar as the concept of corporation is concerned, we had discussed in the last class that this is the first class of legal persons which we have. So a corporation is a group or series of persons which by legal fiction are regarded or treated as a person. Now here it is very important for you to understand that corporations could be of two kinds. They could be corporation sole or they could be corporation aggregate also. Now, insofar as corporation sole is concerned, it consists of an incorporated series of successive persons. So you would find only one member at a time. For example, the Postmaster General of India, the Solicitor to the Treasury, the Secretary of State for War, the Attorney General of India, the Advocate General of Maharashtra, Advocate General of Orissa, and so on. So one person at a time, and after that person say retires or dies, another person comes into picture. So you will be able to locate only one person at a time. Now, in case of a corporation sole, the element of legal fiction involved is that the law assumes that in addition to natural person administering for the time being the duties and affairs of the office, there is a mystical being who is in law the real occupant of the office and who would never die or retire. The living official is merely an agent of this fictional or mythical being. Now the human official, he would come and go, but this legal fiction of corporation would always remain. Now, insofar as corporation aggregates are concerned, it is a group of coexisting persons, and the corporation aggregate can have several members at a time. For example, a registered company or a municipal corporation. Such a corporation, for example, a company, is in law something different from its members. So the property of the company is not the property of the shareholders. The debts and liabilities of the company are also not attributed to members like partnership. So a shareholder may enter into contract with a company for the two person are entirely distinct from one another. Company is a different stuff, shareholder is different stuff in law. So the shareholder who is also a shareholder of the company can also enter into a contract with the company. Now, insofar as the main characteristics of the corporation are concerned, you need to understand that these characteristics are also stated as the uses or advantages of the corporation also. Features of the corporation, characteristics of the corporation, uses of the corporation, advantages of the corporation, it means the same thing. Now see, what really happens is, number one, when a large number of individuals have common interest vested in them and they want to act in common to manage and protect this interest, then the corporation is a useful thing. So it would be impossible for large multitude of individuals, probably scattered over vast distances, to act in a singular fashion. So first feature is common interest. So in these circumstances, when you have shareholders here and there spread everywhere, Incorporation by attaining a personality by legal fiction to the multitude enables the fictitious personality of the corporation to act promptly and decisively in the best interest of the shareholders. That is, all these people who are here, there, somebody in Delhi, somebody in Calcutta, somebody in Dehradun, somebody in, say, Bangalore. So the first feature is, which you read, the common interest. Then independent corporate existence. So independent corporate existence is the most important advantage. So this is different from partnership in the sense that unlike partnership, it has no legal existence. Unlike a partnership which has no legal existence apart from partners, a company has a distinct legal personality in the eyes of law. So by corporation, a company is vested with a distinct corporate personality which is different from the members who compose it. So for this, we would be reading a well-known case of Solomon versus Solomon. Then there is a series of persons. So there is a continuity which we have read. So people would come, go, but the corporation would remain. So there's one very important example which is stated, and that is if because of a bomb blast, all the directors of the company die, still company would remain. New directors would come. So it is called perpetual succession. Now there's one more advantage, and that is to enable the trade. You need there are different interests to be catered. So people invest their money without being able to exercise effective control over the things, and the risk could be enormous. So the device of incorporation enables them to invest the money in a commercial venture without taking greater risk. So risk is less. Then one more advantage is it is capable of owning or disposing property in its name. Then this is easy to understand. It would own, it would enjoy, it would dispose of property in its own name, and the shareholders are not the private and joint owners of company's property. Then the freely transferable nature of shares of the company is yet another advantage of incorporation. So a shareholder can freely sell his shares in the market and get back the investment also. Then it can sue and be sued. These are the characteristics. Now, when you see these characteristics, there are certain liabilities also which are attached to the corporation. So a corporation cannot be sued unless the act is done within the scope of the agent employed by it, and the act done is within the purposes of the incorporation. So the same principles which govern vicarious liability of a principal for the tort of agents or of master for torts of his servants govern the liability of a corporation for the torts of its agents and officials. Now it can sue and be sued for defamation, deceit, that is fraud, and malicious prosecution. So when a suit is against a corporation for any of these torts, the plaintiff, in addition to necessary ingredients, must prove that the servant or agent is acting in the course of employment and the complaint was done by him in the course of employment and for the benefit of the corporation within the scope of the authority. Now, insofar as personal wrongs are concerned, that doesn't go against the corporation. Then a corporation may sue for libel or any other wrong affecting property or business. It cannot maintain an action for personal wrongs, that is libel charging the corporation with corruption, for it is only the individuals and not the corporations which can be guilty of such an offense. A corporation is liable for torts committed by its agents and servants to the extent as principal is liable for the torts of his agent or employer for the torts of his servants, provided the tort is committed in the course of doing an act which is within the scope and powers of the corporation. So it may thus be liable for assault, false imprisonment, trespass, conversion, libel, negligence for that matter. And the corporation may be sued for malicious prosecution and fraud also. So it was thought at one time that a corporation could not be able to do wrongs like malice and fraud because they said corporation has no mind. But then now the law has changed. So insofar as the criminal responsibilities of the corporations are concerned, things have changed a lot since the olden times. So after this, you have two very important cases which you have to know. One is Solomon versus Solomon and Company Limited, and second is Dalmar Company Limited versus Continental Tire and Rubber Company Limited. Now, insofar as Solomon versus Solomon's case is concerned, what happened was there was a trader who sold a solvent business to a limited company which consisted of himself, his wife, and his children. So seems to be a family venture. So in payment of purchase money, the company issued debentures to him. Then company went into liquidation. The question for decision was whether this debenture holder was entitled to be paid in preference to unsecured creditor. You have two kinds of creditors. One is secured, one is unsecured. So the point was whether he should be paid in preference to unsecured creditors. The question was answered in affirmative. So it is clear from this case that a man may become his own creditor by taking debentures from the company of which he practically holds all the shares. He was shareholder also, he was debenture holder also. So insofar as shareholders is concerned, whatever was the remaining amount he paid, then as a debenture holder, whatever was the necessary rights that were to be given to him. So this is a fact this is a fact which we see. Why? Because company has a legal personality different from that of shareholders. So this case also shows one more thing, and that is that one can seek shelter behind this legal person without one's connection or real connection with the corporation being unmasked. Then there's one more famous case, and that is Dalmar Company Limited versus Continental Tire and Rubber Company Limited. This is slightly different because it relates to the concept of alien enemy. Now, what really happened was the respondent company was incorporated in England for the purpose of selling in England tires which were made in Germany and made by a German company also. Now, most of the shareholder of the company were German. So try to understand. Company is as such English. It is selling tires which are made in Germany, and the people involved are also Germans. That is, the shareholders are German. It's just that the company is in England. Remaining all things are German. Shareholders are also German. After the outbreak of war in 1914, that is the First World War between England and at that time England and Germany were enemies. So an action was started in the name of respondent company for the recovery of trade debt. The action was registered on the ground that plaintiff was an alien company at war with England and hence the suit is not maintainable. The contention of the plaintiff was that the nationality of the company was distinct from that of its shareholders and it is registered in England. So the declaration of war doesn't make any difference. Whatever is the responsibility of every Englishman would be applicable to this company also. So this decision was given against the company by the House of Lords. At that time, Lord Parker said, what is involved in the decision of the Court of Appeal is that for all purposes to which the character and not merely the rights and powers of an official personal material, the responsibilities of natural persons who are its corporators are to be ignored. An impassable line is drawn between one person and others. So when a law is concerned with the artificial person, it is to know nothing of the natural persons who constitute control of it. So that is how they made the company responsible. Now, insofar as the remaining part is concerned, that is the theories of corporation, these are very, very simple. We have already done them in class, so we'll just go ahead with a quick revision of the things. Now, what is this fictitious theory or fiction theory? The first thing is people who are responsible or people who are behind this theory were Savage, Salmon, Koch, Blackstone. So this theory says that a corporation is a group of persons which by legal fiction is regarded and has treated itself as a person. So the personality of a corporation is nothing but a fiction which is quite distinct from and stands over the corpus, that is the shareholders and members. So this fictitious being is without a soul or a body, it is not visible, so it is visible only to the eyes of law, and otherwise you cannot see it, you can only see the shareholder. So it is a fiction. Then there is a concession theory, which is it relates to the creation of state. So concession theory says that a concession has been granted. So when you see, they say that a concession has been given by the sovereign of the state and it otherwise has no personality without the state. So this is nothing but an offspring of the fiction theory. Then comes the realist theory. So according to realist theory, a corporation is nothing more in law or in fact than an aggregate of a number of members received as a unity or conceived as a unity, and thus organization of human beings is a real person possessed of real will of its own and capable of actions and responsibilities. This theory would then maintain that the corporation has a real psychic personality recognized and not created by law. So law only recognizes this personality. So Johannes Althusius and Girke are the people behind the realistic theory. So to these two theories, Dr. Setna says one thing, that is to fiction theory and realistic theory. He says that the personality of the corporation is neither truly real nor truly fictitious. So it is quasi-real or quasi-fictitious. It is in between these two theories. Then we read of bracket theory. Bracket theory says that there are a group of people. This came up because of Jering. So bracket theory says that there's a group of people, and around these group of people you would see a bracket. That is A, B, C, D are there. You put A, B, C, D in a bracket, so you would be able to see the corporation. So it's very easy. It's just like writing something inside a bracket. Then comes the Aphelion analysis. Now Aphelion analysis is something which you would be reading again when it comes to legal rights. So Aphelion analysis talks more about the rights and duties which are there. So what could be the rights and what could be the necessary duties of a particular corporation. And then you have the famous concept of Kelsen. Now, insofar as Kelsen's concept is concerned, we need to look back somewhere at what he has been saying about the things. So whatever is the norm of Kelsen insofar as law is concerned, that would be repeated when it comes to the theory is also concerned. Now, with this, we would end this particular topic. And if you have any questions, then you can get back to me. Thank you.